All right, so I will make this a little larger. Can everyone, I think you can all see my screen here, agriculture and alcohol. So Miss Sarah did a great introduction for my background. I did just want to give a little bit more, just to kind of give you some more information. Like she said, so I've been on my own and solo practitioner for about a year. I worked for two other law firms. I worked for one both before and after law school, and I would say they are, probably one of the predominant law firms in Florida dealing with alcoholic beverage law. So a lot of what I did was filling out forms and applications, and I feel like I can do that in my sleep now. And then I sort of progressed into this area because I personally have an affinity for agritourism and trying to make this work on a smaller scale for small farmers and startups. So anything related to the alcohol manufacturing or retail industry, I feel like I've run the gamut. So even if something is not on here and you have a question about it, please ask at the end. I've left a lot of time for that. I know there's not a ton of folks on right now, but feel free to monopolize some of that time. And then the only thing I will say, since I'm going to be the one speaking the most, is I am at home today, so you may hear a dog bark randomly, and I will be sure to cut off my audio very briefly and then get back to it. So I appreciate everyone with their patience on that. All right, so the first screen here is just about key terms. So the main thing that we're going to spend a lot of time on today is my flow chart, which is on the next page. And that flow chart is about how you can serve alcohol at different events. And so you're going to see some terms on that slide. And those terms I wanted to go over briefly because I think this is kind of where questions start and what certain agencies are and the jurisdiction. It can be a bit confusing. So we'll start with, quote unquote, private events and public events. So you'll see on the next page that I've divided it basically between those two types of events. Certainly, there are some events that fall in the middle, what I call quasi-public events, but we're not really going to deal with those today. Those are events that are ticketed with limited capacity, perhaps, potentially a way to get around it being an open to the public event. Certainly, there are some gray areas there, but for now, we're just going to do the very straightforward private and public. So private events are what most folks do in this industry, especially for this time of year. There are a lot of people that they may not operate all the time as, let's say, a wedding venue or something, but sometimes they do rent out their facilities. And so those private events, they have a set number of attendees which are permitted to enter the venue through a contract with the venue's client. So, the way that we all remember what a private event is you've got one main person who is going to be your point of contact. And that's pretty much what makes it a private event. A public event, as it suggests, these are things that are happening like, Oktoberfest and fall festivals. Those things are cyclical and they are advertised as open to the public. And like I said, there are some in-betweens, but we're just going to treat those events that have that limited capacity or ticketed events, we're going to treat those as public for today. You're going to hear me talk a lot about the DBPR. The DBPR is the Department of Business and Professional Regulation. It is the state agency that oversees alcohol, restaurant, and related hospitality licenses. So it is the large entity over these other agencies that I'm going to talk about. So at the end of the day, if you're unfortunately ever in litigation, you'll see the DBPR is the primary party in those actions. And so if you get in trouble with the ABT, it ultimately filters to the DBPR. So the ABT, it's another term you're going to hear a lot today. That's the Division of Alcoholic Beverages and Tobacco. That is under the DBPR. So that is a state agency and it's a division of it. I'm not really going to talk about the federal agency, which is the TTB, Trade Tobacco Bureau. It is more relevant to alcohol manufacturers. There's not a whole heck of a lot that folks that are doing agritourism events have to do with the federal side. There are a couple of forms that are filled out generally if you have an alcohol license. So if that's applicable to you, please raise your hand later if you actually do have an alcohol license on your premise, and I can talk to you about what those forms are. Then we've got our licenses that are going to be the primary focus today. So a 13CT, hopefully folks know or have heard of this license. This is probably the most common for any wedding venue event, or really any event on site where you are trying to serve both food and drink. So the catering license is owned by most restaurants. It allows for off-site service of alcohol so long as 51% of the sales are food and non-alcoholic beverages. So any restaurant, as long as they have a restaurant license, like a 4COP SFS, which is a special restaurant license, they can have these 13CT licenses as well, which allows them to serve off-site. This can also be done by folks who are not restaurants. You just have to have a commissary kitchen. We can talk a little bit about that, but basically it's sort of an off-site commercial kitchen that you either have in your own building, or there are what are called ghost kitchens, and you can rent those out to also use that as your commissary. But these are the most common because really these folks usually have their own setup with bartenders and linens and dining ware. And so they usually can cover a lot of those issues for you if you're new to hosting these events. The 4COP, not to be confused with the 4COP SFS. I wish they made these names a little less confusing, but nothing we can do about it. But this is the other license you'll see on the next page that you're going to want to ask for if you're going to have an off-site vendor dealing with your parties and being the host essentially for these food and drink options. So the 4COP, this is the quota license, not the SFS license. This is what a bar would have. So this is the one that if any of you have ever dealt with the alcohol industry, this is a lottery license. So it is worth quite a bit of money, and there are limited numbers in every jurisdiction. And so the 4COP quota, it's the big bad license that allows you to serve all sorts of alcohol without food, but they are generally very limited. So usually I would not expect you to run into a 4COP quota license. But if you did, you can absolutely use those folks to serve alcohol at your events. They do not need to serve food, which is a great, differential from the common 13CT. The last permit that we'll probably talk about today is the 1-day permit. So this is specific to public events. It's really the only permit that the ABT offers at the state level for public events, and it can be pulled by charity 501c3s or civic organizations. And despite its name, it actually can be used for multiple events. And it's a way for charities that work with farms, or maybe your farm has a charity, you're able to have alcohol for certain events, and you can get money for allowing the use of your land for doing so. So those are our key terms, and we will go into the flowchart. All right, so hopefully you can see the top here. I think you can. All right, so like I said, the public versus private event. So there are limited ways that you can serve alcohol depending on who's providing what. So I will start with the public side because, as you can see, if you follow the green arrow here, there's only one option really. So if you are not a license holder, if you do not hold a alcohol license, like I said, either the 4COP, the 13CT, or a 2COP, then you are stuck with these 1-day permits. So the way these work, like I said, despite its name, it can be pulled for 3 days per event. So it doesn't have to just be 1 day, it can be 3 days consecutively and 12 times a year. So you can do it basically once a month. So this can only be pulled by 501c3s or quote unquote civic organizations, meaning, you're going to file the paperwork through Sunbiz and with the IRS to show that you are for a nonprofit or, civic engagement purpose. So this could be an entity that a farm has. I have several clients that, they have their landlord entity, they have their farm management entity, they have their event management entity, and then they also have their 501c3 entity. It does make a lot of sense when you think about it for farmers and farm organizations, because you do a lot of educational events. There are a lot of different opportunities with charitable events such as, 4-H programs, feeding youth, teaching kids how to, grow vegetables, though those things can all qualify. So basically, how these work, the whole big deal with alcohol is if you're making a profit off of that commodity, off of alcohol, you have to have a license. And so if you don't have a license and you're profiting off of it, there's very limited ways that you can do that legally. The alcohol industry, as we'll get into, it's unfortunately very ambiguous. It does not recognize a lot of new concepts. And so, unfortunately, for my clients, a lot of time the answer is, it depends. But in this case, I've seen it done effectively many times. Basically, as the farm, you're not necessarily making direct profit off of the alcohol sales in this case. This is a charity event. So just think about like a beer festival that you go to that might be ticketed and all the money goes towards charity. But that 501c3 still needs a place to go. They probably still need help with event management. And so the way that your farm makes money in this scenario is actually by sort of hosting it and operating as a landlord. So, like I wrote here, the organization, which again, it can be the same, members as landlord, but it's good to have them separate. But that organization will pay the farm, slash landlord to set a fee for the use of the facilities and event management. And so that's a way, technically speaking, that I don't want to say getting around the profit, but you're not profiting off the alcohol. You are just offering a place for this organization, both one that you may own or someone else's, to host their event. And it's a good way to get recognition in the industry and with your neighbors. So that's really the major way for public events, unless you have an actual alcohol license. So I'm going to actually go over to private events because this venue provided section here could be applicable on the other side. So you're the venue. The best case scenario obviously is to have a service license. Those are consumption on premises licenses, so COPs. They are very, very difficult to get for many reasons. So number one is really, there are very few jurisdictions left in the state of Florida that feel as though, constant alcohol service, which would be the case if you had a license, right? The idea is that you have a premises that always has alcohol, that really is, in sync with farm and with farm related industries. So typically where this dies essentially is with zoning, because with these consumption on premises licenses, even if you've got this wonderful space with 4 walls, the taps, maybe you had a building already on site that had water running, all these great things. At the end of the day, you can't get these licenses without zoning sign off from your jurisdiction. So zoning is going to come in there, and maybe there's a planning and development department, and they might put you through this whole rigmarole, unfortunately. And a lot of times the zoning that you're in, because you're a farm, normally it's either residential or ag or rural. It's not normally commercial. It's not normally these areas where zoning is used to seeing you. So you're already sort of at an uphill battle. And to boot, even if you were in the right place, again, you got the beautiful premises with the 4 walls, and you have the right zoning and all of that. The problem is that actually the service of alcohol itself is limited further in local city and county codes. And so what I mean by that are there are these state statutes that regulate certain types of alcohol consumption. So for the most part, restaurants are fine. That's why you see restaurants everywhere. They can serve alcohol and serve liquor, all of that. That's mostly fine because they're serving food with it. But once you get into, well, I want just a 2 COP, which is just a straightforward beer and wine license. Now you get into what are called distance exceptions. So there are very, very old laws dating back to Prohibition, and stop me if you've heard this before, but basically they limit having alcohol service to schools, to churches, I think in Hillsborough County, they actually run with the land. So let's say 20 years ago, a bar had a 2 COP license and they went out of business, and now it's a dentist's office. It still is a problem. You may only be able to have a limited number of these in an area. So you can see why it's difficult to get these, and it's very jurisdictional dependent. And so you'll kind of see on my next page where I have some best practices that it's so important before you even embark on this, or think you have a great idea here, to talk to zoning or talk to somebody like me just to do a preliminary check on these issues, because it's not just a, hey, I'm in the right zoning and I have the right premises for this. You still may be limited by your proximity to others. So the next thing I put on here, insurance is a pain. So even if you were to get the alcohol license and have it there permanently, the other issue, and I'm sure you have all dealt with this in many facets, but insurance is a problem in Florida, especially for these types of endeavors. So I'm happy to give some information to anyone that needs it. I feel like this is often a big deal for my clients, but basically you need a lot of different policies to overlap and deal with the different things you're doing. And so in this case, when you have a license, when you have one versus the other, your insurance premiums may be drastically different. So a lot of the time, it's easier to get a insurance policy for the service of beer and wine under a 2 COP. But if you want to serve liquor, the liability and the premium just goes through the roof. So this is just another, part of the issue with trying to get a full-fledged license. But I will say, the silver lining is my next comment here. It can be done with what are called farm winery and distillery licenses. So this is a new concept in Florida, but there are several that are successfully doing this. And the idea is that, these statutes were enacted, the ones that are specific to very small micro scale wineries and distilleries, to allow them to operate on a farm. The idea is that, especially with the winery, we have muscadine grapes. You can absolutely have both your agricultural side of growing the grapes with an ag classification, and then also serve the wine there. Same with distilleries, sugarcane, citrus, corn, any of those things potentially can grow here. Maybe not the corn as much, but you get the idea. You can have a manufacturing license and it can be on a farm. Now, this is not an option, I think, that is truly looked at well enough. I think when people hear manufacturing, they say, oh my gosh, I'm never going to be allowed to do that. Well, the beautiful thing is in Florida, you don't actually have to have stills or fermenters to be a manufacturer. So, the secret in this industry, for folks who don't know, is most wineries, distilleries, and even some breweries, they actually just import base, either grain spirits or base wine, or base malt beverage, and they mix it how they want, and then they serve it to you. So it's really not, and it can be done on a very small scale. And I've seen it done. I've had to do many narratives explaining to counties and cities that we're not really doing anything industrial here. It's really them just bringing in a bunch of totes, mixing it together, and labeling it and bottling it. And you'd be surprised that I think there are many more jurisdictions that are open to that if you're willing to give it a shot. So that is a way that I think is the most successful avenue if you want to have a license on site. And like I said, the license that you can have is either that 2 COP, which is just beer and wine, the 4 COP SFS, which is a restaurant, the 4 COP quota, which is just a bar, and then the 13 CT, which is where you don't actually have a restaurant on site, but you can have a caterer's license that comes on there and does the work. So moving on. So the more common option these days is the preferred vendor provided alcohol. So this is where the 13 CT caterers come in. Like I said, they have their bartenders, their food servers and dining ware. it is very, very straightforward. It is done often. It's typically not an issue. The only thing I say here is, you always want to have a contract with these folks and make sure that in that contract you are getting their license up front to show that it's active. You can also look up their license online. The website is myfloridalicense.com. This is the same website you look up contractors, but yes, you can basically type in any entity's name and it'll come up on whether they have a license, whether it's been litigated, all those things. So make sure you get that information from them and their insurance. There's a big thing where I think folks don't think enough about. If you're not serving alcohol on site and somebody else is, somebody's got to have an insurance policy to deal with the alcohol. And so you want to make sure that you get those certificates from these folks to make sure that you are also included as an insured for these purposes, for these events. And like I said, the only drawback with 13 CTs, you have to have 51% food and non-alcoholic beverages. Again, I've never seen it be an issue, especially with weddings. These folks do this all the time, but they can do this for any sort of small events that are on site. 13 CTs, in theory, could do public events. The problem becomes where you're advertising. Please hold. There, you got a good taste of it. See, I thought I would be shown up here, but all right. So the 13 CTs, they can be used at public events, but the issue that we run into is that you advertise for it, right? So you're the agritourism venue. You say, come to our fall in the field. And now you're advertising, well, we're going to have wine and food service. It becomes a way for the ABT to build a case that you are constantly serving alcohol on site to the public kind of at all times. So you can do it. I just would caution that the ABT does actually go through social media, just like the property appraiser does, and they're looking to see how much you are serving food and drink. And the more that you do that, kind of the farther away, you get from doing it legally. I'll say that. And then the last one on here is client provided alcohol. So this is, I think, what a lot of folks do as well. Again, the venue cannot profit off the sale of alcohol, but you can, again, charge for your event management fees, your service fees, and you can actually pick up the client's alcohol. You can help coordinate all of that, but the alcohol has to be in the client's name. You cannot have and basically have this contract that says, hey, we'll pick it up for you. We'll coordinate it all. We'll do everything. We have bartenders. That can be a problem. There's no such thing as mobile bartenders in Florida. So in terms of they cannot provide their own liquor. You can have somebody that bartends, that's great, but a mobile bartender that has a full stocked bar is not a real thing. So you just be careful with this type of client provided. You still are going to want to make sure you know where the alcohol is coming from. And again, you can guide them to, maybe there's an ABC that you always work with. You can have them talk to them directly and deal with what they want. And you can talk to them about how much you think that they should have. But at the end of the day, they need to be the ones on the invoices to make sure that you are not in control and possession of that alcohol. So those are the main ways to have alcohol on site. I do have a little star here about complimentary drinks. That does come up a lot. So it can be done. So if you just, wanted to have your agritourism event and give away free wine, that is totally possible, but you can't make it look like a sale. So like I wrote, you cannot tie free alcohol to any purchase or incentive. So if you're doing a ticketed event with free drinks, that's actually a problem. You have free drinks with swag bags or purchases, that's an issue. And even actually putting tip jars out can sometimes be an improper thing. So it really has to be kind of a public event that anybody can go to, and you can have those free alcohol service, typically wine or beer. I think generally speaking for this time of the year, I think it's expected really that you are going to have events during this time of the year. And I think it's for the most part okay. So when I was saying, that this 1 day permit is kind of the only way to do the public events, that's really the best way to do it. But for this time of the year, I do see a lot of 13CT caterers out there. Just again, minimize your advertising about it. Allow the caterer to do the advertising and kind of tag you in it. Just don't be the, venue that's, we're all inclusive. We have all of these things. Just think about, it's a very limited event. You're doing it just for this time of year, and work with your vendors to have them promote it, and the folks, show up, and it's sort of a separate thing that you're helping to manage. So that is the flow chart. I'm going to get into the best practices to kind of explain some of these things a little bit more. All right. So these are general best practices, but I am going to tie them to alcohol service more specifically. So keep entities separate. That is a big thing in my practice. I cannot say this enough. And then this just ties into a myriad of different things. So all clients that come to me and they'll say, well, I want to do X, Y, Z. I want to have this event management. I want to do outdoor recreational activities. I want to, also have these row crops, and I'm doing this experimental, vanilla bean grow house type thing. So that's great, but the issue becomes liability. Okay. So I know when an attorney tells you, hey, you got to have these different, companies, it's may sound like, oh, we just want to, make the money. But personally, these entities, it's very easy to set up. It does not cost a lot of money. It's like $150 on Sunbiz, and you just have to make sure you're doing your reporting properly. But ultimately, you want to take the extra effort to have these different entities and keep them all in their little houses, their little boxes. When you start to have overlapping entities doing identical things, you're going to run into liability issues. So, number one, landlord, so the person or entity that owns the real estate, the property, they should not also be the entity that is running the events or serving alcohol or any of that. And why is that? Number one is you do not want to subject your land to a personal injury lawsuit. So if you have your LLC as the, doing it all, if that LLC owns property, you're going to have an issue if you get sued by someone. Now, you may be saying to yourself, well, if I build all these other entities, they're probably just going to be the same people. It's okay. That is the point. You just have to make sure, again, that you are honoring these legal limitations, meaning don't have the same bank account between these entities, open different bank accounts, have different, like I said, LLCs, have different, either operating agreements, even if they're just 3 pages long, just make it clear that you are honoring the way that this company is supposed to be run legally, and you do not overlap them. Because once you start to have different entities and then they're all kind of going to the same place, or maybe you're just pulling your salary directly from these entities, that's going to create what's called piercing the veil. And again, you can expose all of your other assets. So my number one thing to folks is, I know it sounds crazy, but you want to have a landlord person entity, you want to have a land farm management entity, and then probably an events management entity. So that way they're each separated. And it also makes sense from the perspective of, you should not have one person doing all of those things. Now, I know when we start out, it is that way, but at the end of the day, you do want someone that specializes in event management, and whether they're an owner or not, they should be under the event management company and not your farm company. And so if you've got a farm operator, you want them to be under that. So you get the idea. And like I said, if you don't do that, you run into liability issues and exposure. And then insurance. Insurance does not want to deal with having all of these different activities being done. I think we all know that from experience. And so it's very important to try to separate out those entities and make sure when you're applying for insurance coverage that you're very specific about the activities of that specific entity, and your other entities can be covered under other insurance policies. The next one here is understand your zoning. So all jurisdictions are not created equal. So I would say, let's say Orange County, City of Orlando, even Indian River County, Vero Beach, Hillsborough, Tampa, Miami-Dade, Miami. Those are tough areas to do the agritourism and do it without having either the property appraiser or code enforcement or the fire marshal on your back. So again, please make sure you have it in your power before you purchase property, or if you already have, go online. They're called GIS maps. Figure out through the property appraiser's website what your jurisdiction is, whether it's city or county, and then go online to the maps, figure out what your zoning is, and then Muni Code, which if anyone was at the Agritourism Association event, that was brought up then. This is an online forum that has, I think, every jurisdiction in Florida, all of their local ordinances. That's where you're going to determine permitted uses. And so it's important to do that even if you have ag classification protection, because as I've seen many times, there's a bit of a fight right now sometimes with property appraisers and agritourism. And so it's not a given that you will keep your ag classification and get all those protections that come along with it. So you want to make sure that even if you didn't have your ag classification and got all of those great protections, that you are in an area that for the most part, you can continue to do what you're doing. Typically, those zones are like ag or rural. And you'll see a lot of language in those ordinances that say, you can process agricultural commodities, you can do, different events, or you can have roadside stands. So you want to be in a jurisdiction where they have that favorable language that kind of already has built in this idea that if you own this type of land, even if it's not a bona fide ag classified farm, you can still do a lot of the things that those farms can do. So I really I think that's one of the biggest things that I run into is folks start these projects and then they run into issues and realize, well, I only have 2 acres of land and my neighbors are very, very close. And, they don't like what I'm doing, and they may be right, which gets into be a good neighbor. So again, that was brought up quite a bit with the alcohol events. It is something that attracts a lot of people, but at the same time, once your neighbors get wind that you are serving alcohol, they are going to be all over the drinking driving issue, traffic related problems. When is it occurring? Are you going to have these things late at night? So again, I think it's best practice to try to limit the event size and number and the time of day. It's always a better idea to have these more towards the daytime, because that's more of a classical time period where folks would have these events back in the day. There did used to be a long time ago, some of these with, grain spirit alcohol, they did exist once upon a time. But you just want to try to keep in line and not have late night parties. Again, use decibel readers. I know folks do a lot of music with these alcohol events. That's one of the big things that I think is ambiguous in terms of when you can get a slap on the wrist for violating that. Police officers don't typically carry decibel readers. So it's up to you to make sure that you are monitoring that if you've got a nosy neighbor, and make sure you are either telling your DJs or telling your folks, what the level needs to be at, and that they even make those things that stop the sound or limit it above a certain range. And so to that note, or to that end, I always get the question about the Right to Farm Act. It is a great thing. It is meant to prevent, to some extent, or limit personal injury or nuisance lawsuits. And so the issue that I run into when I have these types of cases is a lot of times, there'll be a child that gets injured because they're, on a blow up obstacle course, or they're on something that doesn't really scream agriculture. So let's take the example of, maybe somebody is in the parking lot and they have had too many drinks and they hit somebody and then you get sued. What happens is the more events you have, going back to kind of the social media appearance, the more evidence that the other side can get to show that really your focus is on your events and not the ag, the less likely you're going to be able to use the Right to Farm Act to your advantage. And also, the other thing that folks don't realize is the Right to Farm Act only protects you if you were established before the people that are suing you, either moved in or, if it's like a neighbor. So if you have a nuisance suit and it's from a neighbor that was already there and you just moved in and started your big event farm, you're not really going to be protected. So again, just keep that in mind with alcohol service, that it is typically not viewed as incongruity or in sync with ag operations. So make sure that you're trying to limit yourself. And that goes to my next point: accept and address the risk. So again, alcohol laws do not contemplate many scenarios. I wish this was an area of the law where I could say, yes, you can absolutely do XYZ, but it's usually not. So again, there's not a lot of guidance for or protections really for this type of event where you have a farm that just wants to periodically sell alcohol. Really, the only thing that these statutes recognize are those farm and wineries and distilleries. So again, proceed with caution and just understand that you accept the risk. And for the most part, it's okay. Usually the cops can't get involved. It usually does not become a criminal issue. Like I said in this next part of it, the dram shop laws are very favorable. And so those are the laws that say, even if you overserve someone a lot, you're often protected very well. Actually, Florida is one of the states that you are still very protected. But I always tell my clients, whoever's going to be on site from the event management side, they should understand some of the certifications and what to look for when people are over drinking. Because even if, you can't, there's not a lot of significant legal repercussions, you still want to be a good steward of where you live. And then, it should speak for itself, but please start, tell your insurance company before you start serving alcohol. Don't give them a reason to cut you off. You want to make sure that you're upfront, even though it may be only seasonal. But those are good things to say. I think folks underestimate the power of a good email to your insurance company at the outset. It really is one of the things that can save you later on. And so I always encourage clients, when you talk to your insurance company, make sure you're specific. You don't want them to view this as, yeah, we're just going to serve, Bacardi, and then that's all we're going to do and do shots. Obviously, these are mostly seasonable family events. Really paint the picture for yourself that this is just to boost sales and have additional revenue, and it's going to be limited to certain times and places. Those things can matter for insurance companies. So all of these, be a good neighbor elements here about limiting the event and frequency and all the things you do to make sure everything's good, include that in your communications with your insurance company. And then finally, this is just an aside. Especially if you're serving alcohol, it's just more likely people are going to trip and fall, and things are going to happen. I see a lot of things about, well, I'm protected under the non-residential building statute, but it really only protects certain types of permitting for the structure. So, if you're installing a sound system, HVAC, if you have tap handles for alcohol and things like that, you really should get it permitted. It comes down to the protection lives or dies by if you are doing more events than ag in that building. Okay, so if most of the time you're fixing it up and only using it for events, and you don't have, let's say, a nursery operation where you can store flowers and seedlings and things in the building, most likely it's not going to, qualify, or you're going to have a fight about the permitting, and you just don't want to deal with those costs and have a consent order come around later on that interrupts your operations or shuts you down with local government. So I think those are really the main things for this industry. That's my main speech on this type of venue and this type of events. And like I said, I see it a lot across the state. It is becoming very popular. I think it's a very good thing. But I do really, I worry about folks not focusing on the ag at all, and really trying to go towards the event side of it more than anything. So my last little piece on this, which I didn't include, but ag is really the focus. And so if you don't have somebody on your team that their whole life is devoted to, your tulip farm, you need to find somebody, because at the end of the day, this is also meant to support ag industry more than anything. And these additional pieces, if you're doing the ag right, you 9 times out of 10, in my experience, you're going to have less of an issue with local government and the ABT. And so that's it. I think I left, enough time, I guess 15 minutes or so for any questions that anyone has. So I'll open up the floor.
So, Kara, circling back to the free alcohol, because this is a question that comes up a lot. Um, so, for instance, an example, I go to a flower picking workshop where we cut flowers and we make bouquets, and they come around with Prosecco. Is that permitted?
That's okay.
Okay.
Yeah. As long as they're not advertising to say, hey, come, buy a ticket from us and we'll give you alcohol. Just
So, the people who advertise yoga and you get a mimosa, that's it. You can't do that.
So do they do it where, free mimosa at the end of yoga type thing? Is it one of
Yeah.
those? Yeah, yeah. I see it a lot, and so I think people are hesitant to believe that it's not really allowed. But I think most of the time with the mimosa thing, they don't even look at it. But technically, that's not okay, because you're kind of getting them to
Enticing people.
enticing them. Exactly.
Okay. And then Carl had a question in the chat. Given presumed agriculture zoning and the typical limits of same, have you seen any successful applications for a Florida farm alcoholic on-premises license using the agritourism justification?
Yeah, I have in a couple jurisdictions. So there aren't many, but normally it is tied to one, a farm winery or distillery. So I absolutely with, they don't have the ag classification, but they are in a rural zoning. I know there's one in Nassau County right now. And they basically are able to manufacture. They really just bring in, grapes and things like that, but they do serve that wine on site, and they are allowed to serve other wine. And then I think also, there's one going on right now in the Vero Beach area. And that looks a lot more like a classic, commercial development, but it is on ag land, and they are doing part of their property as a row crop, I think. And so they actually will have their ag classification for that. And because they are tying those fruit trees and their crops to the beer that they're producing, that actually is qualifying for part of the ag classification. I know that sounds crazy, but yes, it is. It is done in certain jurisdictions if you can approach these folks in a way that entices them to want this in their city and county. And so a lot of it starts with the person making those relationships in that area. Very political in that way.
Do we have any other questions? This was a lot of information. It's been very helpful. We get a lot of questions from members. And this now I have, as we talked before, flow charts. We can say, okay, this is where you start. This is what you want to offer. This is how you should go about doing it.
Yeah, I didn't get into any of like the application material, so that might be helpful. But if you do go the route of actually trying to get an alcohol license, let's say you're in, I honestly think Mount Dora is a great jurisdiction for the most part. They are very business friendly, I think, and especially on the ag side. And so in those cases, if you go forward with a license, just know that you need to have a lease agreement in place. That's always required with alcohol licenses. There will be a zoning sign off, like I said, and there's also a sales tax sign off. So, you're obviously selling some sort of drink. So you want to make sure you have a DR1 is what it's called. Anybody here that, has to have sales tax on some of their stuff should know what that is. And then you also have a health sign off, which can be the Department of Health, or it can be FDAX, which is the Department of Ag, or it can be the DBPR again under its hotel and restaurant division. So they sign off, and really all that's required there is to have the sinks and have the sinks in the right place and a mop area and a water heater type thing. The bigger issue comes with getting the utility hookups. So, that's more of the zoning, planning, development conversation where you figure out and make sure that you can actually have those water hookups and things like that you would need, or the sewage capacity to have a license on site. That's really where a lot of the issues come in, because if you don't have a license on site, but you're doing a ton of events with alcohol, you get called on because there's, a backup in the sewage, or maybe you're on septic and people can start smelling the septic, or something happens with, water on site that code enforcement sees. So that's really where they start to look at you further. It's either, an impact to the utilities, or it's unfortunately a neighbor that has an issue.
If a farm chooses to distill spirits, is zoning sign off still necessary?
It is required, but again, I've done this successfully. You can do the distilling without actually distilling anything on site. You can get a transfer from, like, let's say you like Kentucky bourbon and you want to do Florida bourbon here. You can absolutely have a relationship with the folks in Kentucky. They bring it down for you, and all you have at your premises is these big vats that you scoop out of, and you add, let's say citrus to it, something from Florida, and then you label it and it's yours. So that can be done, and it's just a matter of convincing the local authorities, because honestly, the biggest issue is the fire marshal with these, because they always think that it's this flammable hazard and it's going to be this huge thing that you need firewalls for and sprinklers. But that can be easily dealt with the right letter from the right engineer, so that they understand that. And a lot of fire marshals ultimately do. I think once you talk to them about it.
What does it mean to be a civic entity through the venue?
Yeah, so a civic entity is just, shy of a 501c3. 501c3, when I say that, kind of sounds scary, but all it really is you have a letter that you write, articles of incorporation that say what your purpose is, your charitable purpose. And with that purpose, you just make sure there's no other legal requirements other than making sure you are legally on Sunbiz, and that you are doing your events in a way that you are allocating it properly to your charity. So as civic events, you obviously don't have that charity status necessarily, but it is still I think it's called low profit. I forget what the technical term is, but it's very similar. So it's a little less liability than a 501c3 from a tax perspective, but you're still kind of doing many of the same things. So you're a civic organization that, even though it's not totally nonprofit, you are advocating for 4-H programs in kids' schools, or you are advocating for teaching kids skills on the farm. And so that's your civic purpose. You file similar documents. And all it comes down to is, really having a good bookkeeper to make sure that you are, when you get donations or when you are advertising, that you're using the money properly, and that when you have these types of events, that you are making sure you are not putting those monies to any restricted funds or towards anything that you're not supposed to. But at the end of the day, for most people, I've seen breweries do this when they want to do beer festivals. It's not super complicated. You just have to make sure that you understand, if you get donations from folks, that you give them their proper receipts, you put it in the proper account, and when you do these events, that you are paying for these events, and you are paying the landlord from the account that you're allowed to pay them from, which is usually separate from where you get those donations and those other monies. It's really a bank account issue more than anything. So civic organizations are just a little less intense, because 501c3s are watched pretty can be watched pretty intensely if you become large enough. So you don't want the IRS coming after you, 5 years into it. So I would always have counsel if you do one of those.
If a farm grows muscadine grapes, it can produce wine. If a farm grows corn or sugarcane, it can produce spirits. If a farm has a restaurant, it could apply for an SFS license. If all require a zoning sign off by a county, is there a path of least resistance to have on premises sale?
So, what would be the path of least resistance zoning wise? So, I think it is harder to do the restaurant because I think a lot of zoning offices automatically just put that into a different um, category. They look at a restaurant as you're not going to have enough ag commodities to supply this restaurant. You're going to have to buy and have distributor trucks. Perhaps it's different if you really do have a lot of different farms. I do have a client that can run his own restaurant because he has beef cattle, he has the row crops and the fruit trees. But for the most part, I think restaurants are more difficult to reconcile with ag. So I think that can be more difficult because even though it's usually exempt from the distance issues, like you can't be close to a church kind of thing, it creates a immediate, oh no, you're going to need to have all these developments in place, and they're going to kind of take you out of the agricultural protections. Whereas with the winery, I think the winery is probably the path of least resistance. It is the most known. I think most folks these days, after 20 years of this happening, they understand that most wine is not, it's not an intense manufacturing process, and most people just get wine from out of state because you can't grow a lot here. And a lot of the muscadine grapes are more for the pictures than the actual growing because it can be difficult. So I think the winery is the answer there. I have seen more counties create ordinances that are specific actually to farm wineries. And so they allow certain consumption on premises. And the beautiful thing is even if you don't have a full-blown license to consume on premises. Let's say you get the winery manufacturing side, but you have issues on the consumption on premise side. You can still, it's much more easy to get them to allow you to do samples and things like that, so that you kind of get there in the same way. So I think wineries are the path of least resistance these days. And I will say, actually, if there's not another question, because I do like to pitch this for these types of events. So, the distillery law, even if you're not interested in distilling, there is going to be a requirement of all distilleries, whether they're on a farm or just in some commercial setting, starting in 2026, where 60% of their alcohol ingredients have to come from Florida. So I'm encouraging a lot of my farm clients to start growing barley or rye or citrus, or start to do sugarcane, depending on where you are, because there's going to be a lot of distilleries in a big panic next year to try to qualify. And if you've already got those things ready to go and you're on the FDAC's website for farms or on the Agritourism Association, pitching that, I think it can be a really good revenue for farms that don't necessarily want to do it themselves.
Interesting. Do you
Yeah, I
have
love it. Yeah, it's definitely a passion of mine. Just to I think this stuff is very interesting, and hope that most folks can be successful.
Do we have any more questions? We're still on. Um, Again, that was just so informative. I can't wait to share this with everyone who signed in. Oh, we have one more. Are you able to provide your email address so we can reach out in the future? Took a lot of notes I'd like to share with management at the farm as we're curious about legal parameters.
Yeah, I should have done that.
I can share it.
Yeah,
If you're okay with that, I can share your
yeah,
contact information when I send the video around.
yeah, absolutely. So you can reach out to me directly, and it might take me 48 hours to get back to you, but I will.
Thanks for the reminder, Angelica. Okay, I don't see any more questions. So, Kara, I want to thank you again for taking the time to do this webinar for us. It's just been very educational. I will share the video with everyone as well as Kara's contact information. And just going to remind everyone that our next conference is going to be in Charlotte Harbor, July 19th through 21st next year. And we hope Kara will be there and all of you. And thank you very much again for your time and to everyone for your support of our association. And we'll see you again soon.
My pleasure. Thanks for having me.
All right, thanks. Bye bye.
Bye.